ಏನಿದು?
Tahsildar recommended for continuation of my license, my lord. And subsequently, my lord, by annexure M, he rejected bar continuation on the ground that, my lord, there is an observation by this honorable court. Earlier occasion, my lord, I have questioned my cancellation by the deputy commissioner on the ground that, my lord, against me there is a criminal case is pending. Therefore, my lord, the writ petition cannot be allowed. Subsequently, I am acquitted, my lord, that is annexure F. Page number 35, I am acquitted. And also I have filed a writ appeal. Without considering those documents, my lord, the writ appeal, it is a intra-court writ appeal, therefore it cannot be, that writ appeal is also dismissed. I am
The
producing.
finding of the learned single judge is affirmed.
Confirmed.
Again,
Thereafter, no, my lord, what happened, my lord, the dismissal itself is for criminal case is pending against me.
ಈಗ ಅಷ್ಟರಲ್ಲಿ ಬೇರೆಯವರು ಕೊಟ್ಟಿದ್ದಾರಾ?
Not yet, my lord. Not yet, in
Very
respect of respondent number 5, my lord, till they have distributing 1,465
Respondent number 4.
votes, my lord.
Votes
Sorry,
Cards.
cards, I'm
ನೀವು
sorry.
ಎಲೆಕ್ಷನ್ ಅಪಿಯರ್ ಆಗಿ ಓಟ್ಸೇ ಬರುತ್ತೆ.
I'm sorry, my lord. Respondent number 4, on the instigation of respondent number 4, my lord, the officers are acting upon. From the beginning, my lord, they are
ಈಗ
abstaining.
ವೇರ್ ಇಸ್ ದಿ ಕ್ಯಾನ್ಸಲೇಷನ್?
Please, annexure M, my
ರದ್ದು
lord.
ಪಡಿಸಿರೋದು ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ಅಕ್ವಿಟಲ್? ಏನ್ ಬೆನಿಫಿಟ್ ಆಫ್ ಡೌಟಾ?
No, ಇಲ್ಲ. ಅದು ನಾವು ಕಳ್ತನ ಆಗೇ ಇಲ್ಲ ಅಂತ. ಒಂದನೇ ಆರೋಪ.
ಯಾರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದಿರ್ಬೇಕು ನಿಮ್ಮ ಮೇಲೆ? ಯಾರು ನೀವಾ?
ಅವ್ರದೇ ಕಂಪ್ಲೇಂಟ್.
No. Initially, my lords, what has happened? Respondent number 4.
ಅದ್ಯಾರು?
It is a organization.
In another
organization.
Oh, you are also
I'm also distribution. Yes.
ಒಂದೇ ಏರಿಯಾ.
my cards are given to them. Interim arrangement. They wanted to continue for 1,400.
If it is only on the ground of criminal case pending or initiated, now that there is acquittal has become final, you will reconsider it. Yes.
Lords, may I make one submission?
ಏನ್ ಸರ್ ನಿಮಗೆ ಎಕ್ಸ್ಟ್ರಾ ಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅದು ಕೊಟ್ಬಿಡಿ ವಾಪಸ್.
Till consideration
that will go on.
Yes.
Time limit.
ಯಾವ್ದಕ್ಕೆ?
Consideration.
Page 22, my lords, are the allegations.
Acquit ಆಗಿಲ್ವಾ ಸರ್?
Acquit agide. My lords, the committal, my lords may kindly see annexure C.
ಅಲ್ಲ acquit ಆಗಿದೆ ತಾನೆ?
Acquit agide.
ಅವ್ರಿಗೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ ಲೈಸೆನ್ಸ್ ಬಿಕಾಸ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
That is also one aspect of the matter.
One aspect ಅಲ್ಲ, only aspect of the matter.
What their locus, my lord.
ಅದಕ್ಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ಪೆಟಿಷನರ್ ಅಲ್ಲ, ವಾಟ್ ದೇರ್ ಲೋಕಸ್ ಇನ್ ದಟ್.
Lords, in fact, this annexure C, this cancellation order was challenged by way of writ petition. Affirmed, my lords, in writ appeal.
Correct, because criminal case is still pending.
No, my lords.
Even acquit ಆಗೋಗಿತ್ತಾ?
ಹೌದು. What is the contention of the petitioner is the learned single judge did not take note of that criminal case and by oversight has passed the order anta ಬರ್ದಿದ್ದಾರೆ. By oversight, the learned single judge did not look into the acquittal order and passed the order anta ಬರ್ದಿದ್ದಾರೆ.
Acquit ಆಗಿರೋದು ನೀವು ಹೇಳಿಲ್ಲ ಕೋರ್ಟ್ಗೆ?
Yes, my lord, it's brought. I have produced the order sheet also. We produced the document. It is not considered by the learned single judge.
Division bench ಗೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತು.
Division bench
ಅಲ್ಲಿ
after
ಇಂಟ್ರಾ
that
ಕೋರ್ಟ್ ಅಪೀಲ್ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. Learned single judge passed an order. A criminal case was registered against the petitioner for illegally storing kerosene. Accordingly, the second respondent by complying clause 12 of so and so. This is the observation. In division bench also, I produced the document, but your lordship kindly see the order. The appellant herein had not produced any record with regard to the contention raised in the writ petition. Hence, we do not find any error committed by the learned single judge so and so. Intra court appeal is that is the observation.
My lords, criminal case, my lords, is filed. This order may kindly be seen, my lords, annexure C for a moment. This order of cancellation.
Original ನಿಮ್ಗೆ ಎಷ್ಟು ಕಾರ್ಡ್ಸ್ ಇತ್ತು?
My lords, original
500.
500.
As per the rules, my lord, 500.
ಈಗ 1500 ಇದೆಯಾ?
496.
1000 cards, my lords.
800 cards. So one village, if it is a village, my lord.
Village
800.
Urban area 800, rural area 500.
It is
Not
a village.
less than.
Not less than.
Not less.
ಅಂದ್ರೆ ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಇರ್ಬೋದು. ಈಗ ಅವರು ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
ಅಲ್ಲ,
ಮತ್ತೆ ಅವರು ಕೆರೋಸಿನ್ ಇದಾದ್ರೆ ಮತ್ತೆ ಮಾಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಮತ್ತೆ allegations is annexure C, my lords, on independent footing apart from the criminal proceedings they have recorded a finding. He has stored 970 liters of
that forms
kerosene.
part of the orders.
ಇಲ್ಲ, ಅದು acquittal, my lords, criminal case was lodged. Milords,
he has stored 970 ಇದಕ್ಕೇನೆ criminal case register ಮಾಡಿದ್ದು.
ಹೌದು. Milords, preponderance of probabilities and beyond shadow of doubt ಅಂತ.
Criminal case.
ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ ಅವ್ರು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕೊಟ್ಬಿಟ್ಟು ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಕಮಿಟೆಡ್ ದಟ್ ಆಕ್ಟ್. But Milords, for the act that has been committed as against the public interest, the order at Annexure C is passed, which was challenged in writ petition, affirmed in writ appeal. So
Yes.
therefore, Milords, after the after the
Focus,
dismissal
my
of the
lord,
writ
only
appeal.
interim arrangement
No, no,
has
may I
been
make-
made, cards are
let me submit,
distributed.
Milords.
The
Let me
government
submit.
has moved.
Let me submit. After
The-
passing of the order at Annexure C, Milords, it has been
Petitioner.
affirmed in writ appeal.
Is before this court, ಅದೆಲ್ಲ show cause notice stage.
ಅದೇ ಅದಾದ್ಮೇಲೆ ಒಂದು ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ. ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ದಟ್
ಅವ್ರು
ಆರ್ಡರ್.
ಯಾರು ಕೇಳೋರು?
ನಾನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಸುಮ್ಮನೆ ಇರಿ.
Lords, as against the order at Annexure M, there is an appeal provision also. Instead of exhausting that remedy, they have filed a
The
writ petition.
petitioner is before this court seeking the following prayer. Heard the learned counsel, the learned AGA appearing for the fourth respondent. The issue in the list revolves around the license to run a fair price shop being taken away by the state on the score of pendency of a criminal case against the petitioner. The petitioner was rendered a license on 27/8/2012 to run a fair price shop. During the subsistence of the said license on certain allegations of violation of section 3 and 7 of the Essential Commodities Act 1975, a crime comes to be registered against the petitioner in CC 236 of 2014. Owing to the registration of the crime, it transpires that the license of the petitioner stood cancelled by issuance of a show cause notice and submission of its reply. In the interregnum, on the score that the license stood cancelled, the cards that were in the that formed the license of the petitioner were handed over to the fourth respondent. It is fourth respondent. The petitioner challenges the said show cause notice so issued to the show cause notice so issued before this court in writ petition 106/305 of 2015, which comes to be rejected by an order dated 20th November 2020, observing that the petitioner had stored 970 liters of kerosene unauthorizedly without any permission from the authorities. The petitioner tossed the said order before the division bench, only to be confirmed on the score that it was an intra-court appeal and there was no warrant of interference. Pursuant to the orders passed thereon, the reply to the show cause notice was taken note of and the license has now stood cancelled. The order of cancellation of license is on a solitary circumstance of the criminal case pending against the petitioner. The learned counsel appearing for the petitioner submits that has been acquitted of all the blame, holding that there was no kerosene stored at all and it was only a complaint that was registered by the fourth respondent. The learned counsel would further contend that the cards that were with the petitioner are now at the hands of the fourth respondent as an interim or a temporary arrangement, and therefore the license along with the cards should be restored by the respondent state. The learned counsel, learned AGA would refute the submissions and take this court through the documents appended to the petition, seeking to demonstrate in defense of the impugned order. The learned counsel for the fourth respondent, he would contend that the petitioner, that's not the only blame against the petitioner, but there are several other allegations. He would thus contend that the petition be dismissed. The learned counsel for the petitioner would now join issue in contending that the fourth respondent has no locus to interfere with the rights of the petitioner accrued in terms of a license that was granted. Temporary arrangement, holder of cards of temporary arrangement cannot have any right to intrude into the petition filed by the present petitioner. The dates and link in the chain of events as narrated herein above would not require any iteration. The issue is why the cancellation of the license of the petitioner happens. The order of cancellation is as follows. Petitioner then files an appeal against the said order before the appellate authority only to be rejected. Therefore, the petitioner is before this court in the subject petition. The, as observed herein above, the order passed by the original.
As against that order that has been
Earlier
passed by
writ
the
petition.
appellate authority, they filed writ petition. Writ petition is dismissed. Writ appeal, it is dismissed.
appeal alva?
After dismissal of the writ appeal, they go and file a representation which is
Annexure E, my
rejected.
lord.
And then the impugned order is passed against which they are before this court. As against that, my lords, they are supposed to follow the same procedure which they had followed earlier. They have to prefer the appeal.
Against the order passed of cancel, show cause notice challenge ಮಾಡಿದ್ದು ಅಲ್ಲಿ.
ಇಲ್ಲ.
Against the order passed
Cancellation order.
cancelling the license, the petitioner prefers writ petition comes to be rejected, and a writ appeal thereon also comes to be rejected. Be that as it may, after the dismissal of the writ appeal, has the impugned order has sprung. One admitted fact by all the counsels representing the parties and perusal at the records is that the license of the petitioner stood cancelled only on the ground of pendency of a criminal case and it is again an admitted fact that the petitioner has been acquitted if pendency or registration of a criminal case against the petitioner was the solitary reason for cancellation of license and the petitioner has now stood acquitted in the proceedings. The respondent state should now reconsider the case of the petitioner for restoration of license, as there was no other ground for cancellation of license. The impugned endorsement would run foul of the said principle. In that light, the petition deserves to succeed on the said solitary ground as afore noted. The state shall now reconsider the claim of the petitioner for restoration of license and the cards which stood cancelled on the date of the order of cancellation. Till such time, the cards that are with the fourth respondent shall not be disturbed. For the aforesaid reasons, the following order allowed impugned orders ಎಲ್ಲ quash ಮಾಡಿ. The matter is remitted back to the hands of the state. Reconsider the case of the petitioner for restoration of license, bearing in mind the observations made in the course of the order. Till such reconsideration happens, the cards of the fourth respondent shall not be disturbed. The reconsideration and consequential action shall be taken within 8 weeks,
12 weeks.
4 weeks,
12 weeks.
within 12 weeks from the date of receipt of the copy of the order, if not earlier.